Well. To all my haters, I have a question. Are y'all not tired of being wrong? Are your fingers not weary from coming to my page and typing thesis statements just for the opinion to come out and for you to realize the judge actually agreed with my analysis all along? That's okay. That's from jump. And I said from jump that there was no conflict. Y'all gonna learn. You don't have to like me right now, but you will. Maybe you'll come around. Anyway, without further ado, let's get into the opinion by Judge Scott McAfee saying that Fani Willis can stay on the case if Nathan Wade gets off the case. And that's exactly what I was saying should have happened from the beginning. So just go ahead and read through this together and discuss. So it starts off actual conflicts of interest. Our highest courts consistently remind us that prosecutors are held to a unique and exacting professional standard in light of their public responsibility and their power. That's true. So I'm a former prosecutor, as people know. And what people always said to me was that, hey, you're held to a higher standard. You are looking for the truth. You're not looking necessarily for a conviction. You're not looking for a conviction at all. You're trying to figure out what's best in the case, what really happened. If what really happened is the police officer lied, then the police officer lied, right? If what really happened is XYZ, that's what you're looking for. But you are not looking to slam people, to harm people. You're looking for the truth and to ferret out what really happened. So that's what the judge starts with in this order here. And I really think that's a really great way to start because we are talking about a prosecutor being disqualified. What are their duties and how do we look at prosecutors in light of prosecuting criminal cases? So the order goes on to say, every newly minted prosecutor should be instilled with the notion that she seeks justice over convictions and that she may strike hard blows but never foul ones. Beautiful. Most importantly, prosecutors are expected to assume a role beyond a mere advocate for one side and must make decisions in the public's interest, not their own personal or political gain. Exactly. You are making decisions for the public, not for your career, not to try to go on and become a senator one day. You're trying to make decisions, criminal justice decisions, for the best interest of the citizens that you serve, which are, in this case, the citizens of Fulton County. So let's jump down a little bit and we get into this disqualification conversation. And what you should see in a really great legal opinion is it's going to lay out the standard, the law, the facts, and then apply the facts to that. When we get here into the law, it talks about the Georgia Supreme Court. So it says the Georgia Supreme Court has most recently denoted conflicts of interest and forensic misconduct as the two generally recognized grounds for disqualification. A conflict of interest includes acquiring a personal interest or stake in the defendant's conviction. And to me, this is something that the defense attorneys could never get over, right? They could never show that Fani Willis, the district attorney in this case, had a personal interest or stake in the defendant's conviction, whether that's her trying to advance her career or get more money or what. They just couldn't prove it, right? Particularly with that relationship with Nathan Wade, they couldn't prove that the relationship between two prosecutors on the same side was somehow her taking in a stake in the defendant's conviction, that she somehow wanted the defendant to get convicted because she had a relationship with her coworker. Number two, the financial gain or benefit, they couldn't show either, mainly because they couldn't show that she was even getting a benefit or a gain, especially when the testimony was that they were kind of reimbursing each other. And sure, there was no ledger. The court's going to go on to say that that was concerning, but they just couldn't prove that there was a financial benefit that she was getting from this. And they also couldn't prove that she was trying to expand or extend the timeline of the case just because she was dating attorney Wade and she wanted him to get more money, because it shows from jump that the state was moving pretty fast. I believe they requested that the case go to trial within 6 months or something, off the bat. So never did the state ever show that they had an interest in delaying this case, which would have harmed the defendant, of course, who wants to see a resolution and not have this case hang over their head for, however many years and months. So that was a really good background on disqualification right there on page 4 of the order. So if we keep going down here, we get into the nitty-gritty, the juicy stuff. So it says, as to the financial allegations, the court makes the following factual findings. Boom. It's going to go into all the separate dates that they went on, that Governor Roy Barnes was considered an option for the case, but he was like, no, I have mouths to feed. I don't want to be walking around with security, all that good stuff. So after we get through all the factual basis of the case, and if you want to look at that, definitely go back and look at some of my older videos where we do go through the testimony, but I want to get to the nitty-gritty of the law right here. So here is the kicker. The judge says, such a reimbursement practice may be unusual and the lack of any documentary corroboration understandably concerning. But the testimony which stood direct contradiction was corroborated by other evidence. For example, her payment of airfare for the two on the 2022 Miami trip, and was not so incredible as to be inherently unbelievable. What that just says is the judge says that the testimony was not so false and so wildly unbelievable that we have to just discredit it totally. He's saying that it's believable. It passes the smell test. It passes scrutiny. So what the judge also talks about, and you can see here that the judge is also concerned about the lack of ledger. It says here, however, as the district attorney herself acknowledged, no ledger exists other than the best guesstimate. and there's just no way to be certain that the expenses were split completely evenly, right? So the judge says the district attorney may have received a net benefit of several $100s. Who knows? We can't prove that. But the court does say that the court finds that the evidence did not establish that the district attorney's receipt of a material financial benefit as a result of her decision to hire and engage in a romantic relationship with Wade. The court just is not finding it, is not buying that whatever that maybe that net $100 that she may have received, but the court can't prove she received, is enough of a benefit to say that she had a financial pecuniary interest in the case. But even more importantly, the court says, in addition, and much more important, the court finds, based largely on the district attorney's testimony, that the evidence demonstrated that the financial gain flowing from her relationship with Wade was not a motivating factor on the part of the district attorney to indict and prosecute the case. The court says it's not like the district attorney was destitute. She says that her salary exceeds $200,000 per year, and there's just no evidence that the district attorney wanted to delay or prolong the case at all. The judge then goes in and describes even more as to why the district attorney did not want to extend or prolong the case. Look here. Before the relationship came to light, the state requested that the trial begin less than 6 months after indictment. The state requested that. Soon thereafter, the state opposed severance of objecting defendants who did not demand their statutory right to a speedy trial. The state amended its proposed timeline in November 2023 to request that the trial commence less than 1 year after the return of the indictment. That's fast, y'all. We have cases that are not as high profile here that last much longer than a year. So for the state to say that they want to try this case within 1 year after the return of the indictment, that does tend to show that the district attorney was not trying to slow down this case, right? And so the judge says, in sum, the district attorney has not in any way acted in conformance with the theory that she arranged a financial scheme to enrich herself by extending the duration of this prosecution or engaging in excessive litigation. Next argument. Y'all just couldn't prove it. So then the judge goes on to wrap this up. Without sufficient evidence that the district attorney acquired a personal stake in the prosecution or that her financial arrangements had any impact on the case, the defendant's claims of an actual conflict must be denied. That's it. Now, the judge then goes on to get his licks in and say that, look, the court does not find Attorney Willis's behavior professional. The court says, this finding by no means is an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing. Rather, it's the undersigned's opinion that the Georgia law does not permit the finding of an actual conflict or simply making bad choices, even repeatedly, and it is the trial court's duty to confine itself to the relevant issues and applicable law properly brought before it. Finally, the court says, look, whether there's other issues between the State Bar of Georgia, the Georgia State Ethics Commission, the Fulton County Board of Commissioners, whether any of these other entities want to discipline the district attorney, that's fine, but that's not what I'm here to decide. I am here to decide whether there is an actual conflict of interest. I find that there is no actual conflict of interest that has not been demonstrated in this case. And as a result, the district attorney is not going to be disqualified from the case. Point blank, period. Now we should move on to the second portion of the opinion, which is the appearance of impropriety portion, which I will say the defense attorneys did win on this issue. So we start off by talking about finding insufficient evidence of an actual conflict of interest is not in the inquiry. What the judge says here is, look, so we found that there was no actual conflict of interest, but that's not all that we had to decide here. We also have to figure out here whether there is an appearance of impropriety. And the judge goes on to give a really good definition and description of what an appearance of impropriety is. While it says, while formally undefined in Georgia precedent, an appearance of impropriety is generally considered conduct or status that would lead a reasonable person to think that the actor is behaving or will be inclined to behave inappropriately or wrongfully. I talked a little bit about this on my other platform, on TikTok, for example. What is the appearance of impropriety, right? Just because it looks like I did something, does that mean that I am then guilty of that thing? Well, no, not quite that. And the judge is going to burrow into it a little bit further. And I want you to get into this definition here to shed more light on what the appearance of impropriety is. The appearance standard recognizes that even when no actual conflict exists, a perceived conflict in the reasonable eyes of the public threatens confidence in the legal system itself. When this danger goes uncorrected, it undermines the legitimacy and moral force of our already weakest branch of government. So again, we see here the appearance of impropriety, right? Sometimes an attorney guiltless in a crime didn't do anything in the case, didn't do anything wrong, but if it appears that you might have done something wrong, or if it causes the public to not have confidence in your performance, then you might be removed from the case because there is an appearance of impropriety. But again, if we harken back to the question as to whether the district attorney is required to be disqualified, the answer is no, right? Look here. The Supreme Court further noted that the disqualification due to an appearance of impropriety should rarely occur where there is no danger that the actual trial of the case will be tainted, right? And we just don't have any evidence that the trial of the case will be tainted here. Also, disqualification is such an extreme remedy, right? And the appearance of impropriety can be cured, it can be fixed by other remedies. For example, the appearance could be cured through screening the affected prosecutor from participation and discussion of the affected case. For example, putting up a wall where, okay, if I'm a prosecutor and I'm biased, I can't talk to any of the other prosecutors in my office about the case at all. They have to keep me completely separate from the case. And that's one of the ways that you can cure an appearance of impropriety. There are so many other remedies besides disqualification, which has always been thought of in the law to be an extreme remedy, that it really is a last ditch effort, a last choice, and we just have to disqualify you because no other remedy would cure this issue. So, as the court goes on to talk about the appearance of impropriety, what that means, it does find that, hey, look, right, we do find that the prosecution is encumbered by an appearance of impropriety, right? The appearance is not created by mere status alone, but comes because of specific conduct and impacts more than a mere nebulous public interest because it concerns a public prosecutor. The decision does go on to say that Fani Willis did mess up or did cause the court concern when she said that her relationship with Wade has only cemented after these motions and is now stronger than ever, right? The court also says it didn't really believe some of Wade's information or some of his documents where it says Wade's patently unpersuasive explanation for the inaccurate interrogatories he submitted in his pending divorce indicates a willingness on his part to wrongly conceal his relationship with the district attorney. So, as the case moves forward, reasonable members of the public could easily be left to wonder whether the financial exchanges have continued, resulting in some form of benefit to the district attorney, or even whether the romantic relationship has resumed. The court says, look, put another way, put simply, an outsider could reasonably believe that the district attorney is not exercising her independent professional judgment totally free from any compromising influences. And as long as Wade remains on the case, this unnecessary perception will persist. So while there is an appearance of impropriety, ultimately the court's going to decide that dismissal of the indictment or forcing the district attorney to be disqualified from the case, those aren't really the right remedies here, especially dismissal of the indictment, which is an extreme sanction, right? Used only sparingly as a remedy for unlawful government conduct. It's just not what we see here. So the court says that the prosecutors essentially have two options, right? Number one, the district attorney may choose to step aside along with her whole office and refer the prosecution to the prosecuting attorney's counsel for reassignment. So she'll have to refer. There's a entity called the Prosecuting Attorneys Council of Georgia, and they are like an independent third party. They're prosecutors, but they're not tied to the Fulton County District Attorney's Office or any particular district attorney's office. And that office that's supposed to be unbiased can take over the case and can figure out what to do with prosecution. Or the judge says that the special assistant district attorney Wade can withdraw and allow the case to move forward without us talking about this relationship, which really should have been the remedy from jump. I really think Wade should have withdrawn from jump as soon as this came out, but I understand why he didn't, because he probably didn't want to give merit to the claims, making it seem like the defense attorneys won by him withdrawing from the case. But this seems like the most common sense approach to the case. So, long story short, the judge did not find that there was an actual conflict, but did find that there was an appearance of impropriety. And ultimately, either Special Assistant District Attorney Wade is going to have to withdraw from the case, which I'm almost positive that's exactly what's going to happen, or the district attorney's office will have to be removed from the case entirely, and the case will have to be referred out to another office. And I do still think the defense attorneys won on some aspects rather, because I think the case has been in the public eye, and a lot of people are now doubting Attorney Willis's credibility. Her reputation has been damaged, certainly by this. And there is an appearance of impropriety. There is an appearance of, well, we don't really know what's going on, like what's happening in this case. So I do think the defense won on that. The court did go on to address two other issues: forensic misconduct and other constitutional violations. And I can talk about those in another video if you guys want to. But ultimately, I do think the big issues were whether there was an actual conflict or whether there was an appearance of impropriety. So the indictment will not be dismissed. The case is going to have to continue on. They're going to have to continue on for trial prep. Now, whether the merits of the case, whether the merits of Donald Trump and his election interference claims, whether those merits are great or not, I don't know, right? I don't know how strong the actual case is, but I do know for now the case is going to continue moving forward. Thank you for watching this video. Don't forget to like and subscribe. If you need any help with your criminal cases, please contact me. We also do personal injury, car accident cases, and I will see you guys next time.